Morning, Karen.
Good morning. How are you going?
Whew, how am I going? I don't know. Well, good, I guess. You can tell by the level of shaving I've been better. I brought a friend along to cheer myself up.
Who's that? Oh, hello.
No, Terry's not interested at all in the webinar today. He's been hearing the practice runs. Now, look, I thought we'd kick off today just one of the things we've been doing, which I think is really exciting, and it's exciting because you've been doing it and I haven't been doing it, is to create two things. The first is a set of questions which we can give to our supervisors about how they check in with people, because we don't want our supervisors going, "You okay?" That actually doesn't help a lot. And from that, we've also drawn a couple of examples of what would be a good pulse survey to check on people. And the reason behind that is we've sort of been inundated with clients saying, look, we're really struggling. In Victoria, there's the sixth lockdown. In Sydney, we don't know when this is going to end. Similar problems are starting to occur in Brisbane and ACT with our clients as well. And they've all agreed we actually don't know quite how to build our supervisor capability. And also we don't have an index inside our business that checks in a very simple way on how our people are going and what we should be doing. So you've been preparing. Do you want to tell me about it briefly?
Yeah, sure. So look, I'm getting the calls and having the conversation with my clients anyway around wellbeing, and there's this heightened urgency around, look, it's getting hard, yeah. So how do we keep engaging with people around wellbeing rather than and do it in a way that's in a more meaningful, or at least for them to feel like it's meaningful and it's hitting through, and that people are hearing them, that they care and they want to help, without sounding as though like a bit of a broken record and asking the same kind of questions every couple of days. So I've created, as a result of that, I've created a couple of questions that are just not in terms of general work questions. They're ones that are related to people's health, and one more around life. So there's a series there, which I'll share with you guys next week. Actually, no, I might even be able to do that even sooner, Andrew. Probably get it out for people.
So it'd be nice to get it out, Karen. I don't know how everyone's going at home, but what we're finding is we're all feeling a bit flat. Candidly across our group, and we started this project a few weeks ago where Karen has created an internal index so that we can actually track how our staff are feeling. So look, Karen will send out both the pulse survey for you to utilise, and it's just an example. You can see how you draft a pulse survey from that, and there's about 25 questions over 5 areas that you can give your supervisors as a bit of a guide. Look, if you want to ask the questions, do, but at least get them engaging, because we're finding throughout Australia our clients are actually starting to feel a bit flat. And Everett, who works closely with Karen, who's our analyst, has also built an index tool. So if you want a bit of hand, please reach out to Karen really quickly. This is a great way of being able to measure the emotional temperature. So I think go for it. Thanks, Norma. You're right. Yeah, lockdown has hit people pretty hard this time. I agree. Yeah. Let's just jump on to what we're doing today, because we've got a pretty full agenda. I spoke briefly about the 4-tier process the Fair Work Ombudsman has distributed last Thursday as advice effectively from the federal government about how you mandate vaccination. And we've seen since that time Qantas mandated, SPC have fought quite strongly and actually released their legal advice to show what they're doing is legally. It is a pretty deplorable situation at the moment that our federal government is dodging this issue completely and is pushing it back on employers to do it. But they're not the only government around the world who's doing it. Most governments are doing the same. We'll publish a list from Nina who shows what are the mandated professions throughout Australia based on state government mandating things. And we've seen New South Wales just this morning said all health workers will have to be vaccinated by end of November. We need to think really carefully about this issue. It's not that hard if you have a client-facing occupation or a high-risk occupation to mandate it, and really it is the only way you're going to get through this and maintain the economy of your business. And if you don't do it, you're going to struggle and fall behind. So the Fair Work Ombudsman advice is there. Nina's going to send you out what are the mandated professions, the mandated businesses at the moment. We'll get that out to you pretty shortly. But I just want you to know we are seeing very quickly governments around the world now starting to move, and our state governments are moving much more quickly than our federal government to mandate vaccination. and we're seeing major employers starting to say, I'm going to do it. How does that feel if you're a middle-sized or small employer? Powerless, I know, but go to the Fair Work Ombudsman advice. Look whether you're tier 1, 2, 3 or 4. If you need a hand, either speak to Karen and I, and we'll give you some pretty simple guidance on how to do. What's the consultation process? What's the health evidence? What's the consultation process? How do you get to the end and get onto it?
Very interesting, Andrew, how quickly it all happens, isn't it? Because I remember just like yesterday, we were just a bit of a shock decision by SPC, but it's actually a really encouraging move.
Yeah, look, I feel sorry for SPC, but the world's changed now because you can vaccinate because there is vaccination, like there are vaccines. I mean, you could mandate it before, but there was no bloody vaccines. So
but they didn't say that.
You weren't going to get it done.
Yeah.
Whereas now we're starting to look at a sort of cornucopia of vaccines that are coming through, and there's plenty of them. I thought we promised for a couple of weeks to talk about the new provisional payments in Victoria. Now, nearly in every state there is a provisional payment system around workers' compensation, where people are paid because there's an acknowledgement by the state governments that people in need of health support should get the health support, and we determine liability at a different time. The Victorian government has looked at the data and it's showing a massive spike in mental health claims as a result of COVID. And I think what they've done is a really good thing. Now, I'm not going to go into this in detail, and there's a reason I'm not going to go to it in detail. It's actually quite complex. Kim's produced a great article along with hyperlinks to the relevant documents, which you'll get out in the next day or two, okay? But the key part of this is if a person puts in a psychological injury claim, then the moment you receive it, you have 3 days in which to submit Part A of the workers' comp claim to the insurer, who has 2 days within which to trigger provisional payments. And those provisional payments will go for around about 13 weeks. I think it's the amount of time. Whether they're accepted or reject the claim in the usual 38-day cycle, okay? And why the Victorian government have done that is they say, look, no matter whether it's work-related or not, we want people's mental health better. We want them cared for. And there's some data around absence from work. What's that data, Karen?
Well, the data has always been, Andrew, that the longer you're away from work, in terms of physical injuries, and certainly with psychological injuries, I dare say that that's probably going to be worse. The longer you're away, the less likely it is that you'll return to do any sort of work.
Yeah, and do you have any direct data there?
Yeah, we do. Got here very quickly.
I can give it to you, actually. It's 20. When they're away for more than 20 days, the chance of returning to any work is only 70% of workers. That's 20 days, any work at all.
Yeah, and then 45 days, the chance of them returning to work is 50%. And when you get to 70 days, the chance of them returning drops like to 35%. So that's huge.
Yeah, so look, I won't go on because Kim's written a great article and I want you to read it and I want you to use a hyperlink, but it is just a fantastic article about this. It's a good thing for Victoria, but it does mean that as employers, the moment you get a psychological claim, submit Part A. You've still got 10 days for Part B. Please reach out to Kim with these things. You're not going to get charged for just chatting to her. Yes, happy birthday, by the way, for Kim recently. I don't think she'll mind saying she's the big 50.
I don't know about that. She might.
If she does, it's too late, Kim. I'm really sorry. I think she looks 40, but maybe she looks younger. Yeah. Okay.
But Andrew, before we jump on to the next one, just a thing about this also, when it comes to psychological claims as well, these mental health claims, I want to keep it at front of mind for people, right? So don't wait for something to come through and then kind of deal with the process from there. Be aware that if there's been a spike, you're going to see that land through your organisation or your teams at some point. So prepare yourself. And from a capability point of view for managers as well, we always talk about performance management, engaging people, all that. That's always going to be important. But when it comes to being able to deal, have these conversations and supporting people around psychological health, if it's going to be one critical area where we need to develop further, it would be that.
Well, look, you couldn't be more timely because what I'm just about to talk about, it's almost like we practiced this before. But the next part is Western Australia's released a draft code of practice on psychological hazards. It reflects the New South Wales code, which has now been adopted under the model health legislation there. And to Karen's point, the New South Wales code identifies with great clarity the types of psychological hazards that exist. And they're things like work design, The thing that we're not getting our heads around now, which is how much do you work, when do you work, what times do you work, what support do you have around work, how are you supervised, how are you managed. The Western Australian draft code is really useful because it actually has a number of really good examples that are attached to the code, but it reflects what New South Wales is saying. So the three things that come out of this is, one, we've gone through three major ages in the last 50 years, and I'm 62, and I look a lot older than that, unlike Kim. It looks a lot younger than her age. I'm trying to dig out of this. I'm not going very well. You know, I came in post-industrialised age where we had long line manufacturing. I then entered into what was clearly a technology age, okay, which is the beginning of technology. And we're now really in a new age, which is an age of disruption. People have tried to talk about advanced technology, but it is an age of utter disruption in everything we do. So we're in a stage of disruption because of COVID. But I don't want you to think that in 2 years' time, we're going to be less disrupted. That's just not true. This has been a great training ground for what our future is going to look like. So the major hazards in the future are going to be psychological. The regulators are gearing up with people who are skilled in identifying psychological hazards. And as you see, there's already been prosecutions starting to commence around psychological hazards. So it means we need to skill our people, one, because our governance register should acknowledge psychological hazards as a key issue. Our risk matrix should acknowledge it. We should actually have interventions starting to happen because this is our major risk, because the major risk is intellectual capital. And if people aren't functioning at their highest level, it's like a machine breaking down, isn't it? Except machines are much more reliable. Machines don't gossip. Machines don't get resentful. Machines don't have difficult husbands. Machines are just machines. People are much more complex. So psychological hazards, I want you to go and have a look at the WA code, okay? I want you to keep the New South Wales code on your desk because it is what reasonable practicability is in Australia at the moment. That's the end of the rant. Okay, long service leave, amazing case in Victoria. Probably the most important case in long service leave in the last 20 years. It was delivered by the employment group on the Victorian Supreme Court and the Court of Appeal, so it's a very strong case. And it completely reverses all the history of argument around people who come from overseas and associated entities accrue long service leave the moment they land in Australia. So I used to do this with AWAs, Karen, for senior employees who'd come from a large health insurer. They'd land in Australia after 20 years service, and they had 20 years long service leave the moment they landed in Australia to start work because of the associated entity rules. What this case said is, unless you're linked to Victoria territorially through payment and management in Victoria, then it doesn't matter whether you're in an entity or an associated entity. It's only your connection in Victoria that creates service. So this was a case about two people who'd worked for 7 years in India for Infosys, so it's a computer company. They were deported out of India back into Victoria, and they were said to have then an immediate entitlement to long service leave. And under the past law, absolutely true. And the Victorian full Supreme Court says, no, it's not. And that applies throughout Australia. Okay, we'll do a deeper analysis and we'll get an article out. But what I want you to think about now is when you're looking at provisioning, which you must do for long service leave, if someone's come from an associated entity overseas, and think of all the people we've had employed recently. Brad, what did you say? I might suggest you see pre-industrialisation. Brad, that's not generous. That's not generous. I was nice about Kim, Brad. That's unkind. But realise that that provisioning doesn't have to occur, certainly in Victoria, and we'll give you some more detailed structure around the article that comes out throughout Australia. So great case. And the last case is Maloof and Pandora, which is a workers' compensation case, but really has quite a broad impact on the way we do investigations. Maloof went to a tea room. He's working at Pandora, and he said some things which are pretty awful about Muslim people and about Islamic religion. It was reported. They did a really good investigation. They used the standard form investigation letters which said, look, this is confidential in nature. You're not to disclose it to anyone else. Now, you've heard me say what a junk jurisdiction workers' comp in Australia is, and it is a real Gumby jurisdiction. Well, Maloof is a case that proves what a complete waste of time the jurisdiction is and how it completely abrogates every other type of workplace law. Because what they found is by denying him the opportunity to chat to other people a person who pretended he can't remember what his conversation was deprived of the opportunity of asking other people what he said. What absolute horseshit. But, sorry, I don't like this jurisdiction, Karen. But they said that was a basis upon which it wasn't reasonable management action. So is there a lesson from this? There's two lessons. A, workers' compensation jurisdiction is a joke. And the second is, if you have a person who's likely to make a workers' compensation claim and they're suggesting they're not quite sure about what they say, make sure you say when you give them the letter, look, it is to be remain confidential. You mustn't speak to other ones. But if you do need to verify something you've said with someone who was there with you, look, let us know and we're open to that. Okay? And that would get around the reasonable management. What a complete nutter joke. Anyway. All right. Now we're on to the big issue for today. And the big issue today, which we promised to talk to you about, was social media. And I guess with social media, there are really major problems. And when Karen and I were in the alleged green room before, and the green room before is now a virtual green room, I was sort of saying that social media is a bit like a virus. You can seed stuff into social media and it spreads rapidly, and it can cause incredible damage, not only to the organisation as an organism, but to the cells, the individuals who sit within it. So we need to understand social media is a great platform. It's a terrific way of connecting. It's made our life different. We've been able to connect and engage during COVID because of it. It's been such a positive thing. But tell us what you really think about it. Word cover. Jeanette, I'm just being kind, what I think about it. I'm being so kind as a jurisdiction. But staying to where I should be, which is on social media, I guess the things that I want you to understand about social media is in the absence of good structure, which Karen's going to talk about later, I want to talk to you about how dangerous social media is and how you actually control it. So I think you have two sort of audiences in social media. If we talk about the internal audience, that is people who may read it at work, be careful of using social media as a tool of trade. Remember, we talked about Accrual and Monards last week, which is where they use Slack and then people misuse Slack for criticising people, managing people. It's a tool of trade. It's only used for engagement. It's not to be used. It's never to replace direct discussions with people, okay? So just that's a warning. The other thing to remember is if you're using it internally and you identify anybody, even if you haven't identified on your profile that you're at work, but you are identifiable because of work or the people within work or the people you are talking about within work, or even in your post, you identify a work situation, I'm afraid that is a work conversation, okay? And if it's visible during any work-related hours, now remember, for most of us, that's 24 hours now, okay? It's not between 9 and 5, okay? If you do that, then I'm afraid those posts, particularly if they deal in threats against people, bullying behaviour, harassing or discriminating behaviour, they're things which are actionable by an employer. And I do want to just remind you that although, again, the Victorian Supreme Court has the leading case on this, but it's been supported in other jurisdictions, privacy settings on your social media sites do provide you some protection around privacy, okay? And remember, information you provide about yourself, your status in marriage, your gender, all those things are private information. And so if you set your privacy settings to its highest and you disclose things on it, it's reasonable to believe that other people outside of those privacy settings should not see them. However, if in doing that you infringe a right in the workplace, then under Jurassic and Department of Transport in Victoria, privacy is waived to allow an investigator without your consent to find whether something is true about something you did to somebody else, okay? Now that's really important because it says to an investigator who would normally under privacy law have to get your consent to look at private information, okay? That they can go around that because of the very temporary nature of posts on social media and the importance of securing accurate information, okay? So, so there's sorry, I'll just read this out. There is another layer regarding social media in schools because of the potential relationships. Yes, that's right. But that's just another linkage between the nature of the inherent requirement of work, which is the way that you get around social media, okay? So you have access to it where those risks arise. Now, obviously, if you have policies and process that Karen talked, we don't have this difficult common law argument. The next one is your external audience. Very clearly, if you publish social media posts about your employer that could do reputational damage and identify, or for the purpose of law, identify who that employer is, and that can be implied or actual. I can say FCW Lawyers, or too late. But if I'm known as the managing principal of FCW Lawyers and I start saying bad things about it, it's a bit too late. Okay.
It's just not even just saying bad things, Andrew. It's also behaviour. You don't have to say any words. It's just your behaviour is captured, and you could be wearing, let's say, the organisation's uniform, and what you're doing, your conduct is inconsistent with what your organisation does and what it stands for. That is also another.
That's exactly right. And look, we saw it at the Royal Melbourne Hospital, where a nurse, who's an unidentified nurse, published some anti-Semitic comments about a party that occurred in breach of COVID rules and was immediately dismissed. Whether she was identified as an employee of the hospital or not, when you do something which is so egregious and you can be implicitly identified, then it's all over. Now, Margaret's raised a case, which is the Department of Social Security case, where somebody made derogatory comments about the Department of Social Security and ended up termination was not accepted for a whole lot of reasons, because there was an entitlement to make reasonable comment, okay? And that goes back to in Victoria, under the Charter of Human Rights that exists here and under implied rights that exist under our Constitution. So fascinating case, Margaret. You must remind me, and we'll go back to it another day. But I want you to understand there are significant rules that sit around what you say and don't say, and that includes things like defamation. So social media, dangerous place, good place. But for today, quickly over to you, Karen, because we've got a big article. I've cut your time down.
Yeah, entirely, down to 30 seconds. Anyway, let's go, Sophie. All right, so this is going out to you all if it hasn't already. So in terms of, okay, so social media, what kind of policies do you need to have in place? So, well, usually it all starts with your code of conduct in terms of who you are, what's important to you, what you stand for, and in terms of outlining the expectations that you have in terms of how people behave, act, and not act. So the social media policy is there. So that's quite clear. Appropriate behaviours policy. Now, many people call it many different things. But when I say appropriate behaviours policy, that covers off your bullying, discrimination, that category of behaviour. Health and safety, it also ties in as well. As does your media and communications policy. So, for example, what are the requirements set for employees in terms of wanting to reach out to the radio or wanting to speak to the news about something that they feel really strongly about? So, set it really clear in terms of what people can and can't do. And also the internet and email usage policy I find really important as well, because you could be signing on to all these social media accounts through your work email address, which is not appropriate at all. So look, overall, the point here is that make it, particularly with employees going from one organisation to another, culturally, we're all very different. What's acceptable in terms of how much we share or not share and how we express ourselves will be different. So these policies here help provide clarity around what good looks like. And when that's clear, it's much easier to manage. So I hope that's helpful to you. If there's anything there that you want to ask me about, feel free to drop me a note.
Very good. Just remember, code of conduct is always the umbrella that all policies fall under, which drives purpose and values. Okay, it must be really clear. Let's jump on, because we've got a big problem and a complex problem today. Okay, Jane worked at Jack Velves, a family business that traded throughout Australia and overseas. Jack Velves was a major employer in Ballarat, and its two owners, who were brothers, were on the board of Midlands Golf Club, the Ballarat Club, and a local private school. Jane was struggling as the primary breadwinner in her house. Ungrateful teenage kids who were fighting and resisting help around remote learning. Her husband, Ralph, had been injured in a workplace incident years ago and was left severely disabled and depressed. She had missed a couple of deadlines at work, managing the complexity of her life. Jane's boss, Dave, sent an email to her saying, "We can't miss deadlines, Jane. Let me know what I can do to help." Jane didn't think it was genuine. Dave was the kind of guy who was friendly to everyone but could go cold and distant himself if he was dissatisfied with your work. He lacked assertiveness. Jane thought everything was easy for Dave, a well-educated single guy in his early 30s who everybody liked. Two of her girlfriends at work had a similar view of him. All three women had grown up and lived in Ballarat all their life. Late one night, after a few too many drinks, Jane vented her frustrations via several posts on Facebook, liked by her girlfriends. At least 90 of Jack Valve's 300 employees were connected as friends on Facebook. The post said, amongst other things, that Jack Valve's allowed people like Dave from Melbourne, who didn't care about Ballarat, to work them like slaves and provided no support. Jane called Dave a slave killer and said Jack Valve's didn't care about its local slaves, only people from the big end of town. Jane had high privacy settings on her Facebook. The post was only up between 11:30 a.m. and 4:30 p.m. and 4 a.m. When she woke up, realised what she'd done and deleted it. Dave was shown a screenshot of the post the next morning. His boss arranged an investigation before talking to Jane to verify the post was real and found it was. Poll. Thank you very much, Soph. Whew. We're trying to catch up some time here.
That wasn't on me, Andrew.
Beg your pardon?
That wasn't on me.
No, that was all on me. It was all me. I think I got distracted ranting about work cover.
Yeah, that's right. All right, we've got most people now, Andrew, so we might just wrap it up in 5.
Okay, sounds good.
All right, 3, 2, 1. Excellent. That's 75%. Oh, nearly 80%. All right, thanks, everyone.
Thank you very, very much, Doug. So the first question is, could you go behind the Facebook settings? The reason the investigator in Jurassic went behind the Facebook settings is because they wanted to verify the post was still there. Okay, they wanted to find, had the post been made, and it was still there, and they found that it was. So there is a question here where we know the post has been taken down, but that's also a relevant issue for an investigation, because if you've got evidence that it was posted and then deleted, it's close to an admission of guilt, isn't it? So the answer is yes, you could still go behind under Jurassic's case. Okay, could Jack Valves take disciplinary action once they had verified that she did the post? And the answer, as all of you said, is absolutely yes. Next question, not so easy. Jane had worked without incident Jack Valves for 20 years. Should she be summarily dismissed? And can I just say, we have great people who listen to us each week and watch us each week, because it's a really hard question, isn't it? I'm not sure that what she posted in itself would be enough to terminate someone. Okay? Possibly is the short answer. So it's on the edge of summary dismissal. Now, if the codes of conduct and the policies and procedures were clear, absolutely. But then you remember the first thing is there a valid reason under termination, unfair dismissal? Yes. Thanks, Brad. Would it be deemed harsh? But the question is, would it be harsh, unreasonable, unjust? Would it be unlawful, unjust? Would it be unreasonable? Were the facts not there for it? But here's someone with 20 years good service who cracked it during a difficult time in her life. And remember, the full bench of the Fair Work Commissioner said personal circumstances are matters which go to harshness. Okay? Her personal circumstances are dire. So I don't think she'd be summarily terminated. I don't think she'd be terminated. If you did terminate her, I think she'd be reinstated.
Yeah, and Andrew, just on that quickly as well, whether or not there's a condemnation at play as well, whether or not there's been other instances like this that haven't been managed this way.
Yeah, no, totally. And look, we don't know what happened to the 2 people who liked. What do you do to the 2 people who liked? Okay, good question. But I just think the fact that we're all over the place as a group shows that we're all really worried about it and we think it's wrong. Jane didn't say she was an employee of Jack Valves on her profile. Does that matter for disciplinary purposes? Peter, Andrew, I think you and I attended the same school as the fictitious company. I think we might have. And the fictitious company is very close to a real company. Oh my God, you've lost me now here. Does it matter for disciplinary purposes? No, because she did identify in her posts the company and the person. And in any event, because of the size of the community, and this is the real key bit, she was known to be a part of that business. So it shows you in a smaller community, or where you're a very well-known person that is identified by that community, that the identification is already made. So it goes against a case called O'Keefe's case, which says you must specifically identify. Okay. And the last question, and it's just on time, is, do the owners have a claim for defamation? The answer is they look like they do, but they'd have to show serious injury, okay, which is the new thing that changed under the Defamation Code. But yes, there has been a publication, okay. The publication contains untruths, so they're the first two elements, must cause damage. And the recent change to all of the uniform defamation legislation is that the two owners and Dave would need to be able to show that they have suffered some injury, serious injury. We don't have that there at the moment, but that makes it interesting, doesn't it? But it shows how defamation can and will be used in the future. Now, look, we're over time. I'm sorry, that's my fault tonight, but lovely to catch up, guys. And thank you very much for all your support. Speak to you soon.
Thanks, everyone. See you next week.
Okay, bye-bye.
Bye.
Keep well.